that the tide is not turning. The tide has turned. We haven't reached the tipping point, it's tipped over. Marriage, the right to marry the person you love is inevitable. And equality for our community is inevitable. And this decision brings us many steps closer. It's truly a thrilling day to be a Californian, to be a member of the wonderful LGBT community of California and of our country, and especially thrilling to be a gay rights lawyer in California. And as a lawyer, I have to read you a couple parts of the opinion. What the Ninth Circuit decided today, and I quote, was, "The people may not employ the initiative power to single out a disfavored group for unequal treatment and strip them without a legitimate justification of a right as important as the right to marry." The court's decision goes on to the most evil and most constitutionally flawed aspect of Proposition 8. Quote, "Proposition 8 serves no purpose and has no effect other than to lessen the status and human dignity of gays and lesbians in California." And to officially reclassify their relationship and families as inferior to opposite-sex couples, and as the court explained, the Constitution simply does not allow for laws of this sort. The court explained, Proposition's only effect was to withdraw from gays and lesbians the right to employ the designation of marriage to describe their committed relationships, and thus to deprive them of a societal status that affords dignity to those relationships. Proposition 8 could not have reasonably been enacted to promote child-rearing by biological parents, to encourage responsible procreation, to proceed with caution in social change, to protect religious liberty, or to control the education of children. Simply taking away the designation of marriage while leaving in place all the substantive rights and responsibilities of same-sex partners did not do any of those things. In deciding the case more narrowly than whether we had a fundamental right to marry, whether all states needed to let same-sex couples marry, but in looking specifically to what had happened in California, the Ninth Circuit today made its decision much less likely to be heard or overturned by the U.S. And while that means that we won't immediately have marriage equality in all states, it does mean, I believe, that same-sex couples in California, our nation's most populous state, are likely to soon to be able to marry again, perhaps as soon as later this year, if the opponents do not ask for en banc review, that is reviewed by a larger number of the Ninth Circuit judges, or if that's denied, and if the Supreme Court denies review, as I think there's a good chance of, because really, all this did was make it, instead of 6 states in the District of Columbia where people can marry the love of their life, it's now 7. It's incredibly gratifying how clearly the Ninth Circuit understood the significance of marriage. As it stated, quote, "A rose by any other name may smell as sweet, but to the couple desiring committed lifelong relationship, a marriage by the name of registered domestic partnership does not. They said, had Marilyn Monroe's film been called How to Register a Domestic Partner with a Millionaire, it would not have conveyed the same meaning as did her famous movie, even though the underlying drama for same-sex couples is no different, and we know about drama. The court explained, we do not celebrate when two people merge their bank accounts. We celebrate when a couple marries. That we recognize. It is the principal manner in which the state attaches respect and dignity to the highest form of a committed relationship and to the individuals who have entered it. And trying to take that away, to take that dignity away from us, is the dark heart of what Prop 8 improperly sought to do. We at Lambda Legal have been fighting for recognition of our family relationships for decades, including the historic Hawaii marriage case nearly 20 years ago that kind of set this all off. And all of us have been fighting for the recognition of our relationships in California for years. We fought against Proposition 22, the Knight Initiative, in the year 2000. We successfully defended legal challenges to California's domestic partnership laws. Many same-sex couples married in 2004 only to have those marriages nullified 6 months later. We all got the legislature to pass bills providing for marriage equality, only to have Governor Schwarzenegger veto them. And we struck down Prop 22 and won the freedom to marry in 2008 before the California Supreme Court and celebrated the marriages of more than 18,000 same-sex couples. And then we all fought against Prop 8. I want to salute and congratulate the plaintiffs in this case and their lawyers, Ted Olson, David Boyes. I'm also very proud of all of the legal talent that went into writing many friend of the court briefs. And I'm particularly proud that the legal theory on which the Ninth Circuit ruled was the legal theory first advanced in the case in a friend of the court brief submitted by Lambda Legal, the National Center for Lesbian Rights, and the ACLU. And again, at the Ninth Circuit. And that the decision relies throughout on Justice Kennedy's opinion in Romer v. Evans, a case won by Lambda Legal and the ACLU. Victories build on victories. And Justice Romer v. Evans led to this great decision. So it, I believe, will lead to victories in other states and on other issues.
Yeah!
Today's decision decides a critically important constitutional principle for our nation, that the people of a state may not strip a group of a right or benefit that they had previously enjoyed on terms of equality with all others in the state without having at least a legitimate government reason for doing so. That reason cannot simply be not liking us. That we or our relationships deserve to be treated with less dignity than those of straight people and theirs. That is what the barest contours of equal protection mean. And I am ready to march and celebrate that simple principle has been recognized by a federal appellate court, the first federal appellate court ever to reach such a decision. in a marriage case. As meaning that Prop 8 is unquestionably unconstitutional, and that the right for same-sex couples to marry must soon be restored in California.
Wendy Grohl, the city controller. I don't think Wendy has shown